Introduction to Notarization. Notarization is a critical process that verifies the authenticity of signatures on documents and ensures the signer's identity. This process helps deter fraud and ensures that documents are legally binding and trustworthy. In the financial industry, notarization provides an essential layer of security and confidence for transactions involving significant assets or legal obligations. It confirms that the parties involved are who they claim to be and that they are signing documents willingly. Understanding the basics of notarization is therefore paramount for professionals working with financial instruments. This course will equip you with the foundational knowledge required to navigate these responsibilities effectively. It covers the core principles and practices that underpin all notarial acts. The financial industry relies heavily on notarized documents for various transactions, including loan agreements, mortgage deeds, and investment contracts. The integrity of these documents is crucial for maintaining trust between institutions and clients, as well as for legal enforceability. A properly notarized document carries significant legal weight, making it more difficult to challenge in court. This protection is vital for both financial institutions and individuals, safeguarding against potential disputes and fraudulent activities. Therefore, a thorough grasp of notarization principles is indispensable for anyone handling sensitive financial paperwork. Role of a notary public. A notary public serves as an impartial witness to the signing of important documents and administers oaths and affirmations. Their primary role is to prevent fraud and ensure that documents are signed by the individuals named in them, willingly and knowingly. Notaries are public officials appointed by a state government, and their authority is limited to the jurisdiction in which they are commissioned. They do not offer legal advice or prepare documents, strictly adhering to their role as impartial witnesses. This impartiality is a cornerstone of the Notarial Act, ensuring fairness and trustworthiness in all transactions. Their duties are clearly defined by state law, which they must follow meticulously. The responsibilities of a notary public extend to verifying the identity of the signer, ensuring the signer understands the document, and recording the notarial act in a journal. This meticulous record-keeping is crucial for maintaining a clear audit trail and for protecting both the public and the notary. Notaries must remain unbiased and avoid any situations that could create a conflict of interest. For instance, they cannot notarize documents in which they have a direct financial or beneficial interest. This strict adherence to impartiality and legal guidelines upholds the integrity of the notarization process, which is especially vital in the financial sector where large sums and critical decisions are involved. Key notarial acts. Acknowledgements. An acknowledgement is a notarial act where a signer declares to the notary that they have willingly signed a document. The notary verifies the signer's identity and confirms that the signature on the document is indeed theirs. This act is commonly used for documents such as deeds, mortgages, and contracts, where the signer needs to affirm their signature before an authorized official. The signer must personally appear before the notary at the time of the notarization. The notary does not need to witness the actual signing of the document, only the acknowledgement of the signature. This distinction is crucial for understanding the scope of the notary's responsibility in an acknowledgement. During an acknowledgement, the notary asks the signer if they signed the document and if they did so freely and voluntarily. Once the signer confirms this and their identity is verified, the notary completes the notarial certificate. This certificate, typically attached to or printed directly on the document, includes the notary's signature, seal, and commission expiration date. The certificate officially records that the acknowledgement took place, providing legal proof of the signer's declaration. It is a fundamental notarial act that adds a layer of legal validity to many financial and legal documents, making them more secure and enforceable. Key notarial acts. Jurats. A jurat is a notarial act where a signer swears or affirms that the contents of a document are true and signs the document in the notary's presence. Unlike an acknowledgement, the notary must witness the actual signing of the document. This act is commonly used for affidavits, depositions, and other sworn statements where the truthfulness of the document's content is paramount. The notary administers an oath or affirmation to the signer, requiring them to attest to the veracity of the information presented. This direct involvement in witnessing the signature and administering the oath makes a jurat a more stringent notarial act. To perform a jurat, the notary first identifies the signer and then administers an oath or affirmation. The oath typically involves the signer raising their right hand and solemnly swearing or affirming the truthfulness of the document's contents. After the oath, the signer must sign the document in the notary's direct view. The notary then completes the jurat certificate, which states that the document was sworn to or affirmed and signed before them. This certificate, including the notary's signature and seal, confirms that all required steps were followed. Jurats are crucial in legal and financial contexts where the accuracy of statements is legally binding. Other notarial acts. Oaths and affirmations. Oaths and affirmations are solemn declarations made by a person regarding the truthfulness of a statement or the promise to fulfill a duty. An oath is a solemn appeal to a deity or sacred entity, while an affirmation is a solemn declaration made by those who object to taking an oath for religious or personal reasons. Both acts carry the same legal weight and are administered by a notary public. The notary's role is to ensure the individual making the declaration understands its significance and is doing so voluntarily. These acts are fundamental for establishing the credibility of verbal or written statements in legal and financial contexts. They underscore the seriousness of the commitment being made. When administering an oath or affirmation, the notary must clearly state the declaration and ask the individual to confirm their commitment. This often involves the phrase, "Do you solemnly swear or affirm that the statements contained in this document are true and correct to the best of your knowledge and belief?" The individual typically responds with "I do" or "yes." The notary does not judge the truthfulness of the statement, but rather certifies that the oath or affirmation was properly administered. This act is often a component of a jurat, but it can also be a standalone notarial act for verbal declarations. Proper administration ensures the legal validity of the sworn statement. Other notarial acts. Copy certifications. A copy certification is a notarial act where the notary certifies that a copy of a document is a true, exact, complete, and unaltered reproduction of the original document. This act is typically performed for documents where the original cannot be surrendered, such as passports, birth certificates, or educational transcripts. Notaries must visually compare the copy with the original document to ensure its authenticity. It is crucial to note that not all states permit notaries to certify copies of all types of documents. Some restrict it to specific categories or prohibit it entirely for public records. Notaries must be aware of their state's specific laws regarding copy certifications. To perform a copy certification, the original document must be presented to the notary. The notary then makes or supervises the making of the copy, or compares a copy presented by the signer to the original. After verifying that the copy is identical to the original, the notary completes a certificate stating that the copy is a true and accurate reproduction. This certificate, along with the notary's signature and seal, is affixed to the copy. This act provides assurance that the copy can be relied upon as if it were the original, which is particularly useful for financial institutions requiring verified copies of client identification or other critical records. Adherence to state law is paramount to avoid legal issues. Notary commissioning requirements. Becoming a notary public involves meeting specific eligibility requirements set by each state's commissioning authority. Common requirements typically include being at least 18 years old, a legal resident of the state, and able to read and write English. Many states also require applicants to pass an exam, complete a training course, and undergo a background check. These requirements are designed to ensure that notaries are competent, trustworthy, and understand their legal obligations. The application process usually involves submitting an application form, paying a fee, and obtaining a surety bond. Each state has unique stipulations, so prospective notaries must consult their state-specific guidelines. A surety bond is a financial guarantee that protects the public from any financial harm caused by a notary's misconduct or negligence. The bond does not protect the notary. Rather, it ensures that funds are available to compensate individuals who suffer losses due to a notary's errors. In addition to the bond, some states require errors and omissions (E&O) insurance, which protects the notary from personal liability. After fulfilling all requirements, the applicant receives a commission certificate, officially authorizing them to perform notarial acts. This commissioning process is rigorous to uphold the integrity and reliability of notarial services, especially in sensitive sectors like finance. Notary tools and supplies. Every notary public requires specific tools and supplies to perform their duties legally and effectively. The most essential tool is the notary seal or stamp, which is used to authenticate notarial acts. This seal typically includes the notary's name, commission number, and expiration date. It must be an embosser or an ink stamp, depending on state requirements, and must create a clear, legible impression on the document. The seal serves as a visible mark of the notary's authority and official capacity. Proper use and security of the seal are paramount to prevent fraud and maintain the integrity of notarized documents. It is a unique identifier for each notary. Another indispensable tool is the notary journal, also known as a record book. This journal is where the notary meticulously records details of every notarial act performed. Required entries typically include the date and time of the act, the type of act, the title or description of the document, the signer's name and address, the method of identification used, and the fee charged. The journal serves as a crucial audit trail and a defense against claims of misconduct. It must be kept secure and private, accessible only to the notary and authorized personnel. Maintaining a comprehensive and accurate journal is a legal requirement in most jurisdictions and a best practice for all notaries. Understanding financial documents. The financial industry utilizes a wide array of documents that frequently require notarization to ensure their legal validity and enforceability. These documents often involve significant monetary value, personal assets, or critical legal obligations. Common examples include loan applications, mortgage deeds, promissory notes, and various types of agreements. Notarization adds a layer of protection against fraud and confirms the identity of the signatories, which is paramount in preventing financial crimes. Understanding the nature and purpose of these documents is essential for a notary public working in this sector. It allows them to appreciate the gravity of each notarial act they perform. Mortgage documents are among the most frequently notarized financial instruments. These can include the mortgage deed itself, which transfers an interest in property as security for a loan, and various affidavits related to property ownership or occupancy. Other critical documents include deeds of trust, which are used in some states instead of mortgages, and escrow instructions, which guide the closing process. Notaries must be familiar with the general structure and purpose of these documents, even though they are not responsible for their content. Their role is to ensure the integrity of the signing process, not to interpret legal clauses. This knowledge helps notaries confidently handle the diverse paperwork encountered in financial transactions. Loan and credit agreements. Loan and credit agreements are fundamental financial documents that establish the terms and conditions between a lender and a borrower. These often require notarization to ensure the authenticity of signatures and the parties' commitment to the agreement. Promissory notes, which are written promises to repay a specific sum of money, are a common example. Notarization of a promissory note provides legal proof that the borrower indeed signed the document and acknowledged their debt. This adds a layer of security for the lender and helps prevent disputes over the validity of the signature. It is a critical step in securing the enforceability of the debt. Security agreements, which grant a lender an interest in a borrower's property, collateral, to secure a loan, also frequently require notarization. These agreements are vital for protecting the lender's interests in case of default. Notarization confirms that the borrower willingly granted this security interest and that their signature is genuine. Other credit-related documents, such as personal guarantees or certain types of credit applications, may also necessitate notarization depending on the jurisdiction and the institution's policies. For a notary, understanding the significance of these documents helps them appreciate the importance of their role in facilitating secure financial transactions. Accuracy and diligence are paramount in these acts. Real estate transactions involve some of the most critical documents requiring notarization due to the high value and legal complexities of property ownership. Deeds, such as warranty deeds or quitclaim deeds, transfer property ownership from one party to another. Notarization of these deeds is typically a legal requirement to ensure the grantor's identity and willingness to transfer title. Without proper notarization, a deed may not be recordable or legally valid, leading to significant complications. This act protects both buyers and sellers by verifying the authenticity of the transfer. It prevents fraudulent property transfers and secures property rights. Affidavits related to real estate, such as affidavits of title or occupancy, also frequently require notarization. These sworn statements attest to certain facts about the property or the parties involved. Escrow instructions, which guide the handling of funds and documents during the closing process, may also be notarized to ensure all parties agree to the terms. The notary's role in real estate transactions is to ensure the integrity of the signing process for these vital documents. They must verify identities, witness signatures for jurats, and confirm acknowledgements. Their meticulous attention to detail helps ensure a smooth and legally sound transfer of property, safeguarding all parties involved in the transaction. Estate planning documents. Estate planning documents are crucial for individuals to dictate how their assets will be managed and distributed after their passing or in case of incapacitation. Many of these documents require notarization to ensure their legal validity and to prevent challenges to their authenticity. Wills, for instance, often require notarization in addition to witness signatures, depending on state law. A properly notarized will provides stronger evidence of the testator's intent and capacity, making it more difficult to contest. This step is vital for ensuring that a person's final wishes are honored. It adds a layer of formal verification to these highly personal and legally significant documents. Trusts, powers of attorney, and healthcare directives are other common estate planning documents that frequently require notarization. A power of attorney grants someone the authority to act on another's behalf, making notarization essential to verify the grantor's identity and intent. Healthcare directives, such as living wills, specify medical treatment preferences and need notarization to ensure they are legally binding. The notary's role in these sensitive documents is to ensure the signer's identity and willingness, and sometimes capacity, without providing legal advice. Their impartial verification helps ensure that these deeply personal and legally binding instruments are executed correctly and will stand up to scrutiny. Client identification procedures. Verifying the identity of a signer is the most critical step in any notarial act, as it prevents fraud and ensures the integrity of the document. Notaries must rely on acceptable forms of identification as specified by their state's laws. Generally, these include government-issued photo identification documents that are current and contain a physical description and signature. Examples often include state driver's licenses, state-issued identification cards, and U.S. passports. The notary must carefully examine the ID to ensure it appears genuine and matches the signer's appearance. This diligence is paramount to prevent impersonation and maintain the trustworthiness of the notarization process. When examining identification, the notary should look for several key features. These include checking the expiration date to ensure the ID is current, comparing the photo on the ID to the signer's face, and verifying that the signature on the ID matches the signature the signer will use on the document. Notaries should also check for any signs of tampering or alteration on the ID. If there are any doubts about the authenticity of the identification or the identity of the signer, the notary must refuse to perform the notarial act. This strict adherence to identification protocols is a cornerstone of fraud prevention in the financial industry, where the stakes are often very high. Dealing with challenging IDs. While standard government-issued IDs are preferred, notaries may encounter situations where a signer does not possess such identification. In these cases, states often provide alternative methods for identity verification, such as credible identifying witnesses or satisfactory evidence. A credible identifying witness is an individual who personally knows the signer, is known to the notary, and can swear or affirm to the signer's identity. This witness must be impartial and have no financial interest in the document being notarized. The use of credible witnesses requires careful adherence to state-specific rules to ensure validity. It is a safeguard when primary identification is unavailable. Satisfactory evidence is another method, which typically involves the notary having personal knowledge of the signer's identity. This means the notary has known the signer for a sufficient period and can confirm their identity based on established personal interaction. Some states may also allow for the use of multiple forms of non-photo identification that, when combined, provide satisfactory evidence of identity. However, notaries must exercise extreme caution and adhere strictly to their state's laws when using these alternative methods. If there is any doubt about the signer's identity, the notary must refuse the notarial act to prevent potential fraud. Prioritizing security and compliance is always the best practice. Notary journal best practices. Maintaining a detailed and accurate notary journal is a cornerstone of responsible notarial practice and a legal requirement in most jurisdictions. The journal serves as a permanent record of every notarial act performed, providing an audit trail that protects both the public and the notary. Best practices dictate that entries should be made contemporaneously with the notarial act, ensuring accuracy and completeness. Each entry must include specific information, such as the date and time, type of act, document title, signer's name and address, method of identification, and fee charged. Consistent and thorough record keeping is essential for accountability. Beyond required entries, notaries should also record any unusual circumstances or observations related to the notarial act, such as a signer's apparent confusion or reluctance. This additional detail can be invaluable if a notarized document is later challenged. The notary journal must be kept secure at all times, preventing unauthorized access or tampering. It should be stored in a locked drawer or cabinet when not in use. Upon retirement or resignation, notaries must follow state laws regarding the disposition of their journal, often requiring submission to a designated state agency. Adhering to these best practices ensures the integrity of the notarial record and protects all parties involved. Performing an acknowledgement is a common notarial act that involves several distinct steps to ensure proper execution. First, the notary must positively identify the signer using acceptable forms of identification, as discussed previously. This is the foundational step to prevent fraud. Second, the notary must ensure the document is complete and that the signer understands its contents. Though the notary is not responsible for the document's legality or accuracy. Third, the notary asks the signer if they willingly signed the document, and if the signature is indeed theirs. The signer must affirm this declaration in the notary's presence. These steps ensure the signer's informed consent. Once the signer has acknowledged their signature and identity is verified, the notary proceeds to complete the acknowledgement certificate. This involves filling in the date, location, and the signer's name on the certificate. The notary then signs the certificate and affixes their official notary seal or stamp. It is crucial that the notary's signature and seal are clear and legible. Finally, the notary records the details of the notarial act in their notary journal, including all required information. This systematic process ensures that the acknowledgement is legally sound and properly documented, providing a robust layer of verification for the document. Each step must be followed precisely. Performing a jurat requires a notary to witness the signer's signature and administer an oath or affirmation regarding the truthfulness of the document's contents. The first step, as with all notarial acts, is to positively identify the signer using acceptable identification. Next, the notary must ensure the document is complete and that the signer understands its purpose without offering legal advice. Crucially, the notary then administers an oath or affirmation, asking the signer to swear or affirm that the statements in the document are true. This solemn declaration is a key distinguishing feature of a jurat. The signer must respond verbally, typically with "I do" or "I affirm." Following the administration of the oath or affirmation, the signer must affix their signature to the document in the notary's direct presence. The notary must physically witness the act of signing. After the signature is made, the notary completes the jurat certificate, filling in the date, location, and the signer's name, and confirming that the oath was administered and the document was signed before them. The notary then signs the certificate and affixes their official notary seal or stamp. Finally, all details of the jurat are meticulously recorded in the notary journal. This rigorous process ensures the highest level of verification for the truthfulness of the document's contents, making it legally robust. Administering oaths and affirmations. Administering an oath or affirmation is a solemn duty of a notary public, requiring a clear understanding of the procedure and its legal implications. The notary must first identify the individual making the declaration. Once identity is confirmed, the notary presents the oath or affirmation in a clear, audible voice. The wording of the oath or affirmation should be precise and unambiguous, typically asking the individual to swear or affirm the truthfulness of a statement or their commitment to a duty. It is essential that the individual understands the gravity of their declaration. This step ensures the legal weight and enforceability of the statement. The individual must respond verbally, usually with "I do" or "I affirm," indicating their acceptance of the oath or affirmation. Some states may require the individual to raise their right hand during this process, though this is not universally mandated. The notary's role is not to judge the truthfulness of the statement itself, but to certify that the oath or affirmation was properly administered according to legal requirements. This act can be a standalone notarial service or, more commonly, a component of a jurat. Proper administration is vital for the legal validity of sworn statements, especially in financial and legal contexts where accuracy is paramount. Certifying copies. Limitations and requirements. Certifying copies is a specific notarial act with important limitations and requirements that vary by state. Notaries are generally authorized to certify that a copy of an original document is a true and accurate reproduction. However, many states prohibit notaries from certifying copies of public records, such as birth certificates, marriage licenses, or death certificates, if a copy can be obtained directly from the issuing agency. This restriction prevents notaries from encroaching on the duties of official record custodians. Notaries must be intimately familiar with their state-specific laws regarding which documents they can and cannot certify. Missteps can lead to legal issues. When a notary is permitted to certify a copy, the original document must always be presented. The notary must personally compare the copy to the original, ensuring it is an exact, complete, and unaltered duplicate. Some states require the notary to make the copy themselves or supervise its creation. The notary then completes a certificate of copy certification, which includes their signature and seal, attesting to the copy's authenticity. This certificate is affixed to the copy. It is crucial for notaries to understand that they are certifying the fidelity of the copy to the original, not the authenticity of the original document itself. Strict adherence to these rules is vital for legal compliance and to avoid liability. Understanding signer capacity. Assessing a signer's capacity is an important, though often subtle, aspect of a notary's duty. While notaries are not medical or legal professionals, they have a responsibility to refuse a notarial act if they believe the signer does not appear to understand the nature or effect of the document. This involves observing the signer's demeanor, responsiveness, and ability to communicate coherently. The notary should look for signs that the signer is aware of what they are signing and is doing so willingly, free from duress or undue influence. This observation is crucial for protecting vulnerable individuals and preventing fraudulent transactions. It requires careful, non-judgmental assessment. Indicators of potential lack of capacity might include extreme confusion, disorientation, or an inability to answer basic questions about the document. If a notary suspects the signer is being coerced or is not acting voluntarily, they must refuse the notarial act. It is not the notary's role to diagnose a medical condition, but rather to make a reasonable assessment of the signer's apparent understanding and willingness at the time of the notarization. Documenting any concerns in the notary journal is a best practice. Prioritizing the signer's well-being and the integrity of the notarial act is paramount, especially in financial dealings where large sums are often at stake. Recognizing red flags and fraud. Notaries play a vital role in preventing fraud, especially in the financial industry. It is crucial for them to recognize red flags or suspicious circumstances that might indicate fraudulent activity. These can include a signer who is unusually nervous or hesitant, someone who cannot produce proper identification, or a document that appears altered or incomplete. Other red flags might involve a signer who is being rushed or pressured by another party, or a document that seems inconsistent with typical financial transactions. Notaries must trust their instincts and remain vigilant. Their role as a gatekeeper against fraud is indispensable. If a notary encounters any red flags, they have the right and responsibility to refuse to perform the notarial act. This refusal should be documented in the notary journal, along with the reasons for the refusal. Examples of suspicious situations include a request to notarize a document with blank spaces, a signer who avoids eye contact, or a document presented late at night in an unusual location. Notaries should never proceed with a notarization if they have reasonable doubt about the signer's identity, willingness, or understanding, or if they suspect illegal activity. Prioritizing fraud prevention protects both the notary and the public from potential harm. Handling special situations. Notaries may encounter various special situations that require careful handling and adherence to specific guidelines. One common scenario involves signers with disabilities. Notaries must make reasonable accommodations to ensure the signer can participate in the notarial act. This might include assisting a signer with a physical disability in signing their name, as long as the notary does not guide the pen. For signers with visual impairments, the notary can read the document aloud if requested, but must ensure the signer still understands and assents to its contents. The goal is to facilitate access while maintaining the integrity of the notarial act. Empathy and adherence to accessibility laws are key. Another special situation involves foreign language documents. A notary public is not authorized to translate documents or to certify the accuracy of a translation. If a signer does not understand English and the document is in English, the notary should advise them to seek assistance from a trusted translator. The notary's responsibility is to ensure the signer understands the document, not to translate it. Similarly, if the notary does not understand the language of the document, they cannot notarize it, as they cannot verify its completeness or ensure the signer's understanding. In all special situations, the notary must prioritize impartiality, legal compliance, and the signer's informed consent, refusing the act if any of these cannot be ensured. Remote Online Notarization, RON. Remote Online Notarization, RON, allows a notary public to perform notarial acts for a signer who is not physically present, using audio-visual technology over the Internet. This innovative approach has gained significant traction, especially in the financial industry, offering convenience and efficiency. RON requires specific technology platforms that ensure secure communication, identity verification, and tamper-evident digital seals. The notary and signer interact in real time via webcam, and the notarization is performed on electronic documents. This method streamlines processes for clients who are geographically dispersed or unable to meet in person. It represents a significant evolution in notarial services. The legal framework for RON varies by state, with many states having enacted specific legislation to permit and regulate it. Key components of RON typically include multi-factor authentication for identity verification, which often involves credential analysis, and knowledge-based authentication, KBA. The entire RON session is recorded and securely stored, providing a robust audit trail. The notary uses an electronic seal and digital signature to notarize the electronic document. While offering numerous benefits, RON also introduces new challenges related to cybersecurity and technological compliance. Notaries must be properly trained and commissioned for RON in their state to perform these acts legally and securely, ensuring the same level of integrity as traditional notarization. Electronic notarization, e-notarization. Electronic notarization, or e-notarization, refers to the process of notarizing documents in an electronic format while the signer and notary are physically present together. This differs from remote online notarization, RON, where the parties are in different locations. In e-notarization, the notary uses an electronic signature, an electronic seal, and an electronic journal to perform the notarial act on a digital document. The core notarial steps, such as identity verification and witnessing a signature for jurats, remain the same, but the medium is entirely digital. This method offers efficiency by eliminating paper, reducing errors, and speeding up document processing. It is a step towards a paperless workflow. For e-notarization, the notary typically uses a secure platform or software that ensures the integrity and tamper evidence of the electronic document. The electronic signature and seal are cryptographically secured, making them difficult to forge or alter. The electronic journal records all notarial acts digitally. providing a secure and searchable audit trail. States have varying laws governing e-notarization, and notaries must ensure their technology and procedures comply with these regulations. While e-notarization streamlines the process, it still requires the physical presence of the signer, maintaining a traditional element of notarization within a digital framework. This blend of traditional and modern ensures both security and efficiency. Ethical conduct for notaries. Ethical conduct is paramount for a notary public, especially when dealing with sensitive financial documents. Notaries must always act with integrity, honesty, and impartiality. The principle of impartiality means that a notary must not have any financial or beneficial interest in the transaction being notarized, nor should they be related to any of the parties involved. This ensures that the notary's judgment is not swayed and that all parties receive fair and unbiased service. Notaries should avoid any situation that could create a conflict of interest, as even the appearance of impropriety can undermine public trust in the notarial act. Maintaining a neutral stance is non-negotiable. Notaries are also ethically bound to protect the privacy of signers and the confidentiality of documents. They must never disclose the contents of a document or information learned during a notarial act, except as required by law. Providing legal advice or acting as a legal representative is strictly prohibited, as it goes beyond the scope of a notary's duties and could constitute the unauthorized practice of law. Notaries must also charge only the fees prescribed by state law and never overcharge for their services. Adhering to these ethical guidelines upholds the reputation of the notarial profession and ensures that the public receives trustworthy and professional service, which is critical in the financial sector. Notary liability and insurance. Notaries public, despite their impartial role, carry significant liability for errors or omissions made during the performance of their duties. A single mistake, such as failing to properly identify a signer or incorrectly completing a notarial certificate, can lead to substantial financial losses for individuals or institutions. This is particularly true in the financial industry, where documents often involve large sums of money. Notaries are typically required to obtain a surety bond, which protects the public from financial harm caused by the notary's misconduct or negligence. The bond does not protect the notary directly, but ensures compensation for affected parties. Understanding this liability is crucial for responsible practice. Beyond the surety bond, many notaries choose to carry errors and omissions E&O insurance. E&O insurance provides financial protection for the notary against claims of negligence, errors, or omissions in their notarial acts. This insurance covers legal defense costs and any judgments or settlements up to the policy limits. While not always legally mandated, E&O insurance is highly recommended as a best practice, offering peace of mind and safeguarding the notary's personal assets. It is a critical investment for any notary, especially those frequently handling high-value financial documents. Being adequately insured is a testament to professional responsibility and preparedness for unforeseen circumstances.